Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. Now let me ask you a question. Can a non-Hindu enter one of these Char Dham temples in the state of Uttarakhand? Well, the answer to this question lies in this very video. In case if you want to download the notes, which I will be using in our today's session, you can go to a particular Telegram channel called as ETS Live. Now the notes are available there, and while you're at it downloading the notes, please do not forget to subscribe to the channel also. So let us start by understanding why have we picked up this topic for our today's video. Now the management committee of these Chota Char Dham temples, Chota Char Dham are Char Dhams located in the state of Uttarakhand, not all across the India, right? Now these Chota Char Dham temples, which are located in Gangotri, Yamunotri, Kedarnath and Badrinath, the management committee of these temples are considering a proposal so as to bar a non-Hindu person from entering into the premises of these temples. Now, where does that idea come from? The committee says that these ideas emerged from local priests, and the committee itself has decided to deliberate this matter first internally, and if need be, they will also discuss it with the Uttarakhand government. Now, as soon as this announcement was made, there were several debates regarding many important aspects. First, is this kind of a ban constitutional in nature or not? Second, if you impose this kind of a ban, then how will you implement or enforce this ban in reality? Third question is that whether there is a historical precedent from one of the judges or the judgment of the higher courts in India which justifies this ban. This is also what we'll cover in our today's video. Now, first let us understand these Char Dhams or the deities itself. In this Char Dham temples, the ownership of the temple rests with the deity. So it is the deity who controls the asset, who controls each and every ritual that goes into this temple. Now, what happens in reality to manage the affairs of these temples, to manage the assets that are vested with these temples, which are huge by the way, there is a proper committee to manage them called as Badrinath Kedarnath Temple Committee. Now, Badrinath Kedarnath Temple Committee actually manages Badrinath Temple, Kedarnath Temple and 45 other temples in the state of Uttarakhand. Now, this body is a statutory body. It is not a private religious trust unlike other similar bodies. Now, this body was formed due to an act called as United Provinces Sri Badrinath and Kedarnath Temples Act 1939, which gives this body a statutory recognition. And this act was amended after independence and after the earlier United State of the Uttar Pradesh was bifurcated into the present states of Uttar Pradesh and Uttarakhand. So, these acts have been amended repeatedly. What you need to understand, the temple funds and assets, as I already told you, they are vested rightfully, or the owner of these assets are deities. But to administer these assets, to manage the affairs of the temple, there is a particular committee called as BKTC committee, which administers all of these aspects. Now, what you're going to understand is that the government of Uttarakhand plays a very important role in management of this committee. First of all, the government of Uttarakhand nominates committee's president. It nominates several other members, also appoints the chief executive officer called as Mukhya Karyakarthi as the chief executive officer of this trust. Similarly, the government in many cases can even supersede the committee's decision, can order for audit of accounts and assets of these temples, and also can hear appeals in case if it is made by the priest against this committee. So all in all, what do you understand? This body is a state body. It is not a private religious trust, and the government of Uttarakhand plays an important role in nomination of the members and control of affairs of this committee. So any action, any decision taken by this committee indirectly is an action taken by the state government of Uttarakhand. Therefore, any of its decision is subjected to full constitutional scrutiny and subjected to judicial review by High Courts and Supreme Court in India. Understood? Now let us understand what are the important constitutional provisions that have been cited to justify this kind of a ban. Many experts or many religious followers or the scholars, they say that the Constitution of India vests them right to freedom of religion, which is covered under Article 25, 26, 27 and 28. Most importantly, Article 25, which guarantees freedom of conscience and the right to profess, practice and propagate religious affairs. This is one of the reasons that is cited by the committee members to impose such kind of a ban. Similarly, there's also an Article 26 which grants religious dominations the right to manage their own religious affairs according to their whims and fancies. So, because of these two articles, the committee members are saying we have a right to manage our own religious affairs, and accordingly, we have decided not to include or not to allow non-Hindu members into entering into the temple. Now, the question came, if you remember, the present governor of Uttarakhand is a Sikh. So many people ask the question, how will you justify not letting the governor of a state entering your temple? So in that case, the committee said Article 25 2b gives the definition of Hindus a broad definition. So according to this article of the Constitution, Hindus actually includes people who follow Hindu religion as well as people who are Sikhs, Buddhists and Jains into the fold. So this is not an exclusionary measure. This is a measure, according to the committee members, designed to protect the sanctity of the temple premises from not letting the non-Hindu members entering it, right? Now, what you have to understand, these two articles are not enough to justify the ban on many grounds. First ground is that Article 25 and Article 26 does not give an absolute fundamental right to manage your own religion according to your decision. It is a qualified right, which means there are constitutional limitations on enjoyment of these rights on the grounds of public order, morality, health, and other fundamental rights. So I can also argue that the right to freedom of religion, it can't override other fundamental rights, right to equality before law under Article 14. It can't even override freedom of movement under Article 19, and it can't override the principle of secularism, which Indian state actually is. The principle of secularism, it states that the state can't discriminate any individual solely on the basis of religion, which it is doing so in order to not let these people enter into the temple. So this is one argument, that yes, you have a right to manage your own religious affairs, but it is not an absolute right. It is qualified by certain constitutional limitations. One of these limitations are this. The second limitation is right to freedom of movement, which is given in under Article 19(1)(d) of the Constitution. This article again is not an absolute right. This is a qualified right, giving you right to move freely throughout the country or throughout the territory of India. Now, there are certain reasonable restrictions which can be imposed on your freedom of movement throughout the India on the grounds of interest of general public and for the protection of scheduled tribes. Now, the restrictions which are imposed generally on a religious identity or a sentiment of a particular community does not qualify the definition of general public. General public in general means all the public. But when these kind of restrictions are imposed, these are restrictions imposed to take care of sentiments of a specific community. So this is another ground why this decision might not stand the constitutional scrutiny. There is also another argument. Many people say that in order to justify you banning certain practice in a temple under the pretext of Article 25 and 26, you have to prove that this practice is essential to the practice of your religion. And this is borrowed through essential religious practices doctrine, which was propagated by Supreme Court first time in the Shirur Mutt case of 1954. This doctrine says that only those practices would be protected under the right to freedom of religion if these are integral and indispensable to the practice of your religion. And to prove that this practice is essential and integral, the burden of proof would lie on the religious body itself, not the people who are claiming the violation of their right. So this is what is called as doctrine of essential religious practices. But even this doctrine might not be able to justify the ban. The reason being, first of all, in Char Dham, there is no historical precedent or even a scriptural or a written evidence that says exclusion of non-Hindus are essential to be worshipped in the Char Dham temples. Similarly, these shrines historically have seen footfalls of foreign tourists, of religious scholars belonging to other religion, and even non-Hindu devotees. Even if you remember in Sabrimala case, the Supreme Court ruled that long-standing exclusionary practices can't stand the constitutional scrutiny if they fail this religious essential practices doctrine, which this particular practice might not be able to justify. Now, what you have to understand, there is a precedent not so long ago. In 2024 in January, the Madras High Court, specifically its Madurai bench, it ruled it upheld an installation of boards which restricted non-Hindus beyond the Kodimaram of certain Tamil temples. Kodimaram are basically flagpoles. Now, the important distinction between this judgment and the decision that we have covered are many. First, that this ruling, which was given by the Madurai bench of the Madras High Court, it concerned itself only to prohibition of people entering into inner ritual spaces, not the entire temple complex. Similarly, this rule or this judgment was relied on an existing rule of the government of Tamil Nadu, and it does not bind, which, as this judgment was a judgment of Madras High Court, it does not bind the Supreme Court of India, and it does not even bind the Uttarakhand government. Right? So this is why this decision might not stand the scrutiny of the constitution. Similarly, there will also be certain practical and administrative challenges in implementing this kind of a measure. First, even if approved in principle, how will you identify the religious identity of people who are visiting the temple? What about people who belong to interfaith family? Similarly, what about non-believers who actually worship the deity? How will you justify them not entering into the temple? Also, even if there is no strict definition of who is Hindu and who is not, there is a possibility that the implementation of this rule might become arbitrary or might be selective. Some cases you are allowing people, some cases you are not allowing people to enter. So when these kind of inconsistencies happen, courts are generally afraid of giving approval to such kind of a decision because they won't stand the test of reasonableness, right? So for Supreme Court to justify any ban, it has to justify whether this practice is reasonable or not. And if it is facing implementation difficulties, naturally, it won't be as reasonable as it might be. Okay. Now, before we move to the practice question, which I've curated keeping exactly UPSC requirements in mind, there is an important announcement. Now, the article that we covered directly deals with the fundamental rights aspect, and fundamental rights are very important as far as UPSC exam is concerned, and this belongs to Indian polity. To know more about Indian polity as well as other important subjects of UPSC, you can take admissions in the resolution batches in the StudyIQ. Resolution batches are offered in English in bilingual format as well as in purely Hindi basis. The decision is yours. The batch is starting from 7th of February. So to take admissions in these batches, just go to our website. There are two separate batches, one for students who are looking to give exams in 2027 and another for students who are looking to give exams next year in 2028. But please remember, taking admission into any of these batches or even optional subjects, if you apply the code ATS Live before making the payment, you are going to get maximum discounts, right? So this is applicable on all the courses. Please remember, learn to thrive with ATS Live. Now, the question I was talking about, this is a question very similar to the question that appeared on Right to Privacy in 2018. Just look at this question. Freedom to administer religious affairs is guaranteed under the Constitution of India. Which of the following in the Constitution correctly and appropriately implies the above statement? Do let me know the correct answers in the comment section. And what do you feel about this ban? Is it justified or is it not? Please do let me know whatever you feel in the comment section. The comment sections are open for all the opinions, but please be very civil about it. Okay. And the notes, if you are waiting to download, please go to this Telegram channel. The Telegram channel is called as ATS Live. Okay. So I'll see you again. Please have a very good night. We'll see each other again tomorrow.